For the next speaker of the day, we are honored to welcome Ms. Tanya Goddard, a distinguished attorney at law, independent arbitrator, and mediator with 2 decades of experience in both contentious and non-contentious legal practice. She holds advanced legal qualifications from the University of West Indies and Usgood Hall Law School, and is a fellow of Chartered Institute of Arbitrators as well as CEDR accredited mediator. Ms. Goddard currently serves as the Secretary General of the Arbitration and Mediation Court of the Caribbean, where she leads efforts to promote international commercial dispute resolution across the region. She also chairs the Barbados chapter of CIAB and co-chairs the Caribbean Committee for the campaign of greener arbitration. We invite Ms. Tanya Goddard to share her insights on ADR in Barbados and contribute to today's session. I now hand over the virtual stage to you, ma'am.
Hello, thank you very much for this kind opportunity. I'm just checking to see if I have a quick presentation. I was wondering if I'm able to share it. Let's see. Well, it doesn't matter. I can continue. Before I begin my presentation, first of all, greetings, good day, good afternoon, good night, wherever you are in the world. Before I make my comments, on the developments in arbitration in the English-speaking Caribbean, I just want to make 3 quick points. First, I am truly honored to be here. These are the events that remind us that arbitration is truly an international field to be in, and you never quite know when the opportunity would arise for you to participate in these types of esteemed events. Second, my other point, which I wish to share, is that fun fact, if everyone doesn't know, the Speaker's chair in the House of Parliament in Barbados was donated by the government of India since 1966, when we became independent. And we recently had a visit from a group of esteemed politicians from India, and they took pictures of being by the chair. It's a beautiful wooden chair carved, and we've been using it since it was donated to us by the government of India. So these types of collaborations have been going for quite a long time. We may not consider it, but they have been, and it just shows how we do operate within a global context. And the third I want to say is to INBA. As an organizer of these types of events, I could not imagine the logistical feat that this is, of having persons from various time zones and coordinate them. So I truly tip my hat to you, sir, because this is quite the feat. Let me just say that. Just so I start, is it possible for me to share my screen? No, okay, that's fine. So let me start by talking about the various developments within the Caribbean, because what is very important for us to understand is that the English-speaking Caribbean is a complex melting point. And for those of you in jurisdictions where that's the case, I think they would be quite the understanding as to how that arises. Historically, we have a very mixed history with various groups being brought to the region. So we have our First Nations people, our indigenous persons, and then through colonial groups, we've had quite the mix. Now, having said that, oh, I think I've got it now. Oh, yes, great. I've got it. My apologies. Great. So having said that, we have to understand the English-speaking Caribbean in context of what we call CARICOM. CARICOM is the Caribbean community, which was organized under the Treaty of Chaguaramas 1973 and revised in 2001. There are 15 member states, 5 associate states, and who are of various ethnicities, as I started to say. There are Africans, obviously. There are people from Indian descent, Europeans, Chinese, Portuguese, and Javanese. And we also have a mix of religions within the region. Christianity, for obvious reasons, Hindus, Muslims, Jews, those who practice what we call traditional religions. So there's quite a melting pot. CARICOM is headquartered in Turkey, which is in Guyana. And what is important in CARICOM for our purposes is that a lot of decisions which affect the region are made at the CARICOM level. For instance, later on in my presentation, I'm going to discuss the various updated arbitration legislation that was passed. That model arbitration bill was the product of a Canadian-funded project called Impact Justice Project, where they brought several esteemed jurists from within the region to draft the model arbitration bill. And that was subsequently adopted by the LAC, which is the Legal Affairs Commission of CARICOM, which is a grouping of all of the attorney generals and solicitor generals from the various member states, which I stated. So just for context, I have a little map here to show you how diverse. We have the Bahamas and Cayman to the north of the region. We have Belize, which is in Central America. And then to the south, we have Guyana and Suriname. So you could well imagine, the complexity of the layers. What is also important to understand here is that they have various economic sectors, and they also have various languages and so forth. Actually, in St. Lucia, for example, it has a civil code context to it within a Commonwealth-speaking Caribbean. And similarly, in Guyana, it's Roman Dutch influences for some of its property matters. So you can appreciate that there is some complexity due to our historical context in which we're operating. In terms of the Caribbean, we have two appellate courts, again, adding to the layer of complexity. We have the Caribbean Court of Justice, which was established in 2005. I had the privilege of being, just before I left law school, to attend the opening. And then I also had the privilege to be part of the first case that came before them under its appellate jurisdiction. It is the judicial institution of CARICOM. It has two jurisdictions. It has an original jurisdiction to interpret the Treaty of Chaguaramas, and it also has an appellate jurisdiction, where it is the final court for some of the states. Unfortunately, even though there are 15 member states and 5 associate members, there are only 5 countries which have signed on to the Caribbean Court of Justice, being Belize, Dominica, Barbados, Belize, Dominica, Guyana, and St. Lucia. The other jurisdictions within the English-speaking Caribbean still use United Kingdom, the board of the Privy Council, which many of you would be familiar with. Hence, the melding of these various appellate courts and case law can lead to very interesting developments. Now, what I will do going forward in my presentation, I'm going to look at some of the recent legislation that has been passed with respect to arbitration, and also the case law. What we have found within the jurisdiction is, depending on where you are, each one has a focus for its economy. I think many of you would appreciate that. So if you are in Guyana and Trinidad, they are oil and gas related. They do a lot of, Guyana has mining, exploration of gold, extraction of gold and so forth. If you were in Barbados, there is the issue of offshore financial services and renewable energy. We are one of the leading markets for solar power within the region, if not the world. And if you are in the Bahamas and Cayman, BVI, definitely you are looking at the provision of offshore services. And sprinkled in there is quite a lot of construction arbitration as well. So each jurisdiction has a niche in terms of the types of arbitration matters that come from them. Having recognized that having a robust arbitration system is important for the development of foreign direct investment, respect for the rule of law, we have seen over the last 10 years or so an escalation in the number of jurisdictions which have updated their legislation. And just for reference here, I have the last 5. British Virgin Islands Arbitration Act 2013, Jamaica Arbitration Act 2017, Trinidad and Tobago Arbitration Act 2023, Bahamas Arbitration Act 2023, and Guyana's Arbitration Act in 2023. So definitely you can see that there has been a renewed interest in arbitration. I'd like to say that it was purely indigenous coming up as a grassroots, but what I will proffer as a suggestion, as a contributing factor, is the increase in international investments and having law firms and investors who, because the conventions such as the ancestral model, and which these all are modeled after the ancestral model on arbitration law, the New York Convention. I always like to say these pillars of the international commercial arbitration are meant to travel. They speak the language of international business. And as a result, these jurisdictions, understanding their importance, have felt the need to upgrade their legislation accordingly to provide an inviting environment for international investors. My next slide, which I'll go to, will talk about some of the incentives that we've seen across the board. And there are 2 types of sweeteners, as a colleague of mine would say. Now, one of them goes to practical issues such as exemption from specific tax liabilities like VAT and so forth, or the exemption from the requirement for work permits in order for international arbitrators, if they need to, or even regional arbitrators, should they be traveling from one jurisdiction to the other to conduct arbitrations, they wouldn't need to ask for work permit, as that could sometimes take a considerable amount of time. But also we have found our procedural enhancements as well. So we have procedural efficiency with respect to the availability of consolidation within these legislations, evidentiary standard, the weight, where we talk about arbitrator having the ability to consider all types of evidence and giving them the appropriate weight. We've actually seen that codified in some cases, especially where there's still what we refer to as a British protectorate. We see them skirting around the issue of litigation funding, be it conditional fee agreements or third-party funding. For many of us within the English-speaking Caribbean, and those of you would be able to tell me from your respective jurisdictions, the topics of maintenance and champerty still maintain, and as a result, third-party funding for many of the jurisdictions are not allowed. I should have said earlier, which I'll mention here, is that of these, when I showed you the map of the CARICOM and the various states, what is very interesting, which has added some complexity, is that the legislation across the region varies from that which mimics very old 1958 and 1887 English legislation, all the way to modern legislation reflecting what was the UK 1996 Arbitration Act and so forth. So the understanding and the interpretation of arbitration across the region can somewhat be disharmonious as a result, because the legislative framework in which some of these arbitrations are conducted is quite antiquated. But I do think with these developments, we will see more and more jurisdictions updating their legislation. So as I said, in addition to issues of litigation funding arrangements, we also see codification of the finality of awards and judicial support of arbitration. Many governments have spent time having their judiciary trained in international arbitration to understand its benefits and to also allow them to act efficiently, because many of these jurisdictions also have separate commercial courts. And obviously in commercial matters, you're going to see arbitration come up quite a lot. And as a result, the various governments have had their judiciary trained in that regard. So we're seeing progress. Those of us within the bubble, as we like to say, would like it to be quicker. But what I think my preference is, I prefer steady, where we have adopted definitely international best practices for the good of the region. And that really, for me, is a consideration to be had. Now, so that's just a quick look at some of the developments within the case law, within the legislation in terms of the incentives it provides and providing an environment which international investors would be comfortable in. I'm not, for the purposes of today, because I only have about 25 minutes to talk about the ISDS factor, but we do see a number of jurisdictions. I think there are about 3 countries right now within the Caribbean, the English-speaking Caribbean, who have appeared before who have cases before ICSID in different types of matters. Oil and gas again, smart contracts for transportation, and I think one was hospitality. Now, having had a nice framework supplied by the legislation, I want to touch briefly on the role of centers. And this is why the work that your INVA is doing is so important. I would tell people that these are important. As stated in my, so what we have in the region, especially those who've had updated legislation, is we have a number of arbitration centers. They are about 4 and 5. Barbados has 1, Jamaica has 1, Trinidad has 2, Cayman has 1, and BVI. What we all agree on, because we do try to have a collaborative relationship, is that we have, as centers, multiple roles. Not only do we have to grow awareness about the use of arbitration and ADR in general, but part of it is capacity building. I am with the Chartered Institute of Arbitrators. As indicated in my bio, we teach arbitration. We also try to host practitioners workshop for those who don't necessarily want the qualification, but they want an understanding of the framework. We host training for media, and we also still have to host, mediation and arbitration, because that is our business. Just as an idea of some of the things we've done, when I became Secretary General, just before the pandemic, could you imagine, 2020? I started in January, and by February, March, the pandemic broke. One of the issues we wanted to address, which we'll speak to diversity later, is to open the panel. Most centers have a fixation on the recognized names, and I think that is good. It grows authority and it shows that you have the necessary gravitas. But equally important is the development of your domestic or regional arbitrators who may not get the opportunity to participate in the larger, more established centers, but they have qualifications, they have undergone training. What they lack is the experience, and that is one of the greatest hurdles for young and upcoming arbitrators and mediators to get. And one thing we considered was we asked persons who had the necessary experience to submit their CVs to be considered for our panel, so that we can grow ADR regionally at a very grassroots level. I also did a survey for SMEs, because we found that small businesses weren't utilizing arbitration as much, or mediation as much as they could. They did not understand best practices in terms of preventative measures. So we had a survey there. We also conducted mediation training for virtual mediations, which has its own ethos behind it. And definitely because of where we are in the region, diversity was big. It wasn't just about gender, it was about persons who may have challenges and disabilities. It's also about those from various backgrounds who were not necessarily lawyers, but maybe in finance or construction, all of those things. And finally, for me, I am the co-chair for the Campaign Agreement Arbitration Caribbean Subcommittee. We are acutely aware of climate change and its challenges, and felt that one of the ways we can contribute to the conversation was to have our ADR practitioners understand their role. So that's just there's a lot that can be said about the role of centers and how pivotal they are. And I implore all of you in the panel who are here today to support your regional centers. We need it. That's how we get to develop arbitration properly within our region, and we can grow it to international best standards. So I always campaign for that, to support your regional center. Next, a quick look at two cases which recently came out of the Caribbean, the English-speaking Caribbean, which are somewhat interesting in that they challenged our traditional ideas of where is arbitration a suitable remedy, because we also understand contracts and so on. One is Family Mart China Holding Company and Ting Chuan. This one's a landmark decision because it dealt with whether certain aspects of company law are arbitrable. In this case, it was a company that was winding up. It was a joint venture agreement between Family Mart China, which is a chain of convenience stores in the People's Republic of China, and they had a joint venture agreement. There was a petition to wind up the company because there were issues within the joint venture. And one of the Court of Appeal, it came up in the Cayman Islands, and the issue was, can a wind-up petition, is it arbitrable? And we have found, as parties have more and more sophisticated financial instruments, that these are considerations coming before courts, hence the importance of training your judiciary in understanding. The matter went before the Privy Council. Mr. Chuan raised 4 points, which he thought should have been resolved by arbitration. And the board confirmed that yes, the arbitration, that tribunal has jurisdictions to make certain orders, but there are areas which they cannot. And therefore, it's found that they can arbitrate matters which underlie the winding up, but not necessarily the winding up petition as itself. So you can see the case law pushing the realms of where we see arbitration functioning. And that's why Family Mart was such a groundbreaking decision. I'm just cognizant of the time, because it shows the interplay between arbitration and winding up in jurisdictions of the common law, especially if your winding up legislation is outdated. You could imagine the challenges. The second case I want to bring, which is also quite interesting, is the arbitration of internal trust disputes. We have seen that some arbitration legislation have considered it. It's become a hot topic. This is a wealthy family from Nigeria who incorporated a company in the Bahamas. And they eventually, what happened is that the settler to the trust redistributed the assets, much to the annoyance of one of the beneficiaries. The challenge with a trust is that you have to be a party to an arbitration agreement. But if you're not a party, as the beneficiary, whatever outcome comes about from the arbitration, you're affected by it. So you could well imagine there is this beneficiary who's, to their mind, disadvantaged by something the settler has done, but they can't do anything about it because, as far as they're concerned, they are not a party to the arbitration agreement. And this was also an interesting case. The court, as being pro-arbitration, allowed the matter to be resolved by arbitration. So we're seeing those types of cases which are pushing the envelope in terms of arbitration. Next, the benefits. You talk about the choice of the arbitrator, being confidential and flexible, and finality of the award. All of those were taken into context with the use of having trust arbitration and it being part of their legislation. Just as a roundup, because we are discussing ADR, I want to talk about mediation for 2 minutes. It is available. We have a court-connected arbitration mediation program, and I'm rostered with the Supreme Court of Barbados, for example. It is available through the courts, institutions, and privately as well, but very few jurisdictions have legislation outside of the court directives, like, directives number 1, directives number 2, but it is available. What we've also seen is the brave step by a few countries within the region to sign on to the Singapore Convention on Mediation, which was in 2018, and we have 4 states, Belize, Grenada, Haiti, and Jamaica, who signed on in 2019. What I will say is it hasn't been put to the test as yet, but I'm very much intrigued to see how it would operate in practice within the region, because we tend to, because of the informal and flexible nature of mediation, there is only 1 or 2 jurisdictions have legislation, such as Trinidad, and the others don't. So I'm interested to see how it would be implemented. What we're also seeing as when we talk about the future, so we're seeing the update in legislation. We are seeing also the types of topics being expanded in terms of trusts and company law issues. I recently attended a workshop where they discussed the mediation and arbitration of tax disputes, especially under the OECD model, under Action 14. That's also something. So we see the expansion of mediation within these various, and arbitration within these various sectors. And what it also does is it gives opportunity to many upcoming arbitrators to be in what I like to call the non-traditional sectors. And because international arbitration is by its very nature international, you can be where you are and be part of matters which are elsewhere, and if you are multilingual, better yet. So therefore, the opportunities are slowly expanding for persons who are within the ADR sphere. So this environment where you have not only countries updating their legislation, but also the expansion of areas where they want to conduct ADR, be it arbitration or mediation. I use those because those are the more recognized. It is creating an environment, but I will say this, for us within the region, it is slow and steady, and it is with opportunities such as these, where we get to share our understanding and our knowledge that are so crucial to the development of ADR practitioners in the region. Now, I wanted to say that the number that I was in the presentation, I started to feel, I don't know how many of you are cricket fans, I started to feel like a night watchman. And I was a little concerned because by then everybody, the state of play at the end of the day, everyone's a little tired. but that's the role of the night watchman to keep the overs going until. So I do appreciate everyone's patience in staying up. I know it's quite late where a lot of you are. So I do very much appreciate, but since the pitch was so well prepared, I felt like Jason Holder coming up to the wicket. And I said, I still have to do my thing. So thank you very much for this kind opportunity. It is very much appreciated. And all the best. It was fantastic, really was. Yes, thank you so much.
Sir,
Yes. Yeah. Tanya, as a beginning remark, we from KFCRI are quite thankful for your initiatives through the Arbitration Mediation Center or the court in the Caribbean community. And we need to have a long-term relationship so that the traditional connect should be viable in the modern era of ADR. Thank you once again, Tanya, for joining and sharing the perspective about the Caribbean community ADR.